Today we're going to look at a purchase and sale contract for real estate. In most states there is a standard purchase and sale agreement that's usually provided by the Association of Realtors. Sometimes there may be another organization, sometimes it's a title company or even a government agency provides a standard contract. Now, in most states it's not required to use any one particular contract, but the one that's provided has been prepared as a means and a template to meet all of the requirements for the statutes of that state. So if it's being provided by, in this case, Association of Realtors, that association presumably has gone through the trouble of reading through and understanding all the laws of that state, of that jurisdiction, to make sure the contract meets those standards. Your particular area may have a different contract. The important part of this particular video is not to necessarily understand this Florida contract, but what are the important features of any contract? What happens if there's a default? What happens if a buyer decides not to purchase? Who's responsible for closing costs? All of these are addressed in any contract, and we'll talk about what those mean using this as an example. Remember, we're not attorneys. We're not giving you legal advice. Prior to entering any type of major purchase, you want to get good legal advice from an attorney. But here are the things to look at in a contract so you know what they might mean. So first, you'll see that each line has a number next to it, even lines where you don't fill anything in. Line 52 talks about not conditioned by buyer. The reason for that is if you need to reference a certain line in the contract elsewhere, you can reference that line. You also are allowed to make adjustments. Parties can cross something out and initial it. As long as that change is legal, you can do that. In addition, be aware that real estate transactions in the U.S. are governed by a legal theory called the statute of frauds, meaning that real estate transactions need to be done in writing. You can't do verbal agreements for real estate. So that's the reason why having these contracts is important. So let's go through it. Basics, the buyer and seller are identified. Line 1 is the buyer, purchaser. Line 3 and 4 is the seller. You have a property description, street address, what county it's in. That's going to be important because real estate records, deeds and liens and mortgages are recorded in records at the county level in most of the country. There's a few states that do it at the city level. So if you have an address, 12 Main Street, you need to know what county that's in. In addition, there's a property tax ID number. This is kind of like a registration number for the county only for property taxes. It's not like a title number for the legal description. We'll get to what that is in a minute, but at least tell you what the property tax ID number for the tax assessor. The next 3 lines are the legal description of the property. If lengthy, see attached legal description. Here's why that's important. A property address is not sufficient to identify a particular property because 12 Main Street might actually have 3 legal parcels on it. A street address is really just what the mailman uses to deliver mail. It's not a legal description of the property because, for example, like we said, 12 Main Street might have 3 legal parcels on it, or one parcel might be 12-14 Main Street if it's a duplex. So the property address is important to give you a general idea of what the heck we're talking about for a house, but you do need a good legal description that will appear on all of the transfer documents like deeds and mortgages. Then it'll tell you how the property is going to be transferred. The property will be conveyed by statutory general warranty deed. That's important. A warranty deed is different than a quitclaim deed. Warranty deed gives you certain protections as a buyer. Make sure that you're understanding what type of deed you're getting. Again, can't say this enough. If you're unsure, get good legal advice. Notice in bold it says under Florida law, financing of a buyer's principal residence requires the spouse to sign the mortgage. And if you're buying a property, from a person who's married, the seller's spouse has to sign the deed even if the spouse is not on the original deed because of community property laws. Then it'll talk about the price. The price to be paid for the property will be as follows. A binder, which kind of like is a deposit, is what you give with the contract. Paid here within or due within so many days. Date of acceptance. So let's say you put down $5,000 deposit. An additional deposit, maybe another $5,000 within so many days, and you can fill in the blanks before a certain calendar date or within certain days of acceptance. So now you have $10,000 paid to hold that property. You may also have a note, meaning that a mortgage on the property. You may have seller financing. If there is, that would go here. And then the balance due is what you have to come up with remaining at closing. So if you have a $500,000 property, you have $10,000 deposit, and you have a $400,000 mortgage, well, now you owe another $90,000. The total of all those numbers is your purchase price. You notice the purchase price doesn't come first, and you subtract these. You put in all of the numbers to add up to the purchase price. It also tells you who's going to be holding on to that deposit. It might be the real estate broker. It might be a title company. It's usually not going to be the seller, but it could be. No, there's usually no prohibition against that. But it'll tell you who's got the money. Note, in the event of a dispute between buyer and seller regarding who gets to keep the deposit, the broker's resolution remedies are not available, meaning that if you have arbitration or mediation for the broker, you can't use that to determine who gets the money if there's an attorney holding it. What about financing? You're going to need to determine on this contract, is it cash? Are you getting a loan with a contingency, meaning that if the loan doesn't go through, you get to back out? Okay? Or you could do, I'm getting a loan, but doesn't matter. If the loan doesn't go through, you can't back out as a buyer. And if neither box is checked, the loan approval is not conditioned upon the closing of the sale of another property, meaning that sometimes you can do a current property contingency. So if you're buying a new house and you're selling your old house, you can make it contingent upon you selling your old house first before you buy the new house. As an aside, this day and age in 2022, a lot of these contingencies are being rejected by sellers. Sellers don't want any contingency. They just want you to say, I'm buying your house, that's it. In the past, a lot of transactions were based on contingencies. Now, what about different types of loans? There's FHA loans, there's VA loans, conventional, seller financing, assumed mortgages. By checking one of these boxes, you're identifying which financing type is being used. And the reason why is because different financing types might have provisions that affect the transaction. If it's an FHA loan, for example, the seller might have to do certain inspections and representations. VA, same thing. It gives you different protections for that borrower. Conventional loans, those are the normal type of mortgages most people have. Sometimes there might be seller financing. That's not as common anymore, but there used to be, and sometimes still is, examples where the seller is willing to give you a loan. So if the house is $500,000, you pay $100,000 as a down payment, and the seller will hold a mortgage for $400,000. You pay them back. Not as common, but some sellers still like that because it's like an investment. And it gives authorizations for the lender to get settlement statements. What about title? So title to the property needs to be examined before the closing. And the seller will give marketable title to the buyer. And they have to give that evidence so many days before the closing. So that way the buyer has an opportunity to review it, maybe have an attorney review it to make sure the title looks good. And what is marketable title? That means a title which a Florida title insurer will insure as marketable. So there is title insurance on properties to ensure that the title to the property you get is good. So that if any claims come up later, some prior owner says, no, that's my house. Or some prior lien holder says, I never got paid off. Or an heir to a property 20 years ago says, I never got my share of that property in the probate, in the will. The title insurance will take care of that. That should be something that's found in a title search and examination. But if for some reason there was an error or a defect, you can get title insurance. In most cases, that'll be part of the closing. So make sure you understand what goes into title insurance. And that's referenced here in the contract. What about extensions? If a closing cannot occur on the established closing date, then there's allowances for that. Depends on the reason. If it's because of something that has to do with CFPB, which has to do with the mortgage or delivery requirements, then it'll be extended. No more than 10 days. If it's some outside force, terrorism, war, then there's a provision for that. If there's a title problem or survey problem that says there's defects, the buyer will have 5 days to notify the seller that those defects are there. Remember how we talked about before having the title evidence be presented a certain period of time in advance? This is why. Because if the buyer sees that there's a title problem, you have to tell the seller. The seller agrees to use reasonable diligence to cure the defects and will have 30 days to do so. Again, these can be changed. You can make it 15 days, 20 days, but that's the standard. So basically, this is a provision. If there's a title problem, you tell the seller, they have an opportunity to fix it. It's important to have that in the contract. The title evidence and municipal lien search has to be provided to the seller. What about survey? If you are buying a property and you're not exactly sure of the boundaries, or even if you think you are, you want to have it in writing, you want to get a property survey, which will be a document that will show you the exact boundaries on a survey document to know where your line markers are. There have been many cases where somebody buys a house, buys a property, and thinks that their property line is here at the fence, but come to find out it's 10 feet in. Or they think that they have property that extends to the little river or stream, but it doesn't go that far. A survey will show you that. A survey requirement is optional. You can check off the box, no survey is required. That's up to you as a buyer and seller to decide how you want to address the survey. What about casualty loss? What happens if there's a major damage event to that property before the closing? Well, basically in this contract it says if the cost of repair is less than 3%, then the seller has to pay for it and the closing will proceed normally. If the cost of repair is more than 3%, the buyer can terminate the agreement if they want, or they can negotiate to have the seller fix it within 30 days. And then the closing will occur within 20 days hereafter. Here's the thing. These details are for this contract. Look at your contract and understand what the terms are. What if the place gets hit by lightning and burns to the ground? What are you going to do? Probably as a buyer, you don't want to buy the house, even if they fix it. You're going to find a different house. What if a tree falls and damages the deck? Well, maybe you still want to buy it, but you want the seller to pay for the repairs. Make sure you understand who's responsible for losses. Here's an important part. Closing cost. Buyer will pay, and you check off whatever boxes the buyer's going to pay for. And all these different things are closing costs. Credit report, appraisal fee, title search. What are you paying for? Other, you can add that. What is the seller going to pay? Is their closing costs, what they pay. Title search, title insurance, survey. And this is customizable. You can check off which things, who is paying for and who's not paying for. And Each contract may have things that are customary in certain areas, but this is decided upon when the contract is being negotiated. Real estate commission, that's part of the listing agreement. Normally the seller pays that. There's other fees and charges, property assessments that go into it. You want to know who's going to be paying for those things. Here's an important part. Special assessments. If you're buying a property that is part of an HOA or a tax jurisdiction, which almost every property is, or even a municipal utility system like a water service or electrical service, there's fees that go along with that. You might pay $20 a month for an HOA, or your taxes are $5,000 a year, or your water bill is $100 a month, whatever it is. Occasionally, those taxing or billing organizations will have a special assessment. What that means is, look, we've been collecting this money every month or every year for the last 10 years. We found that there's this big expense. We have to put in a new sewage treatment plant. We have to put in a new water purification system for the Water Bureau. The taxing authority says we have to build a new school. Or the HOA says, hey, we found out that the community swimming pool in the HOA needs to be completely redone. The money we have doesn't pay for that. So we're going to issue a special assessment, meaning that every property owner in that jurisdiction has to come up with X amount of dollars, $1,000, $2,000, $10,000, whatever it is. If there's a special assessment, the seller is supposed to disclose that and decide who's going to pay it. Does the seller pay it? Does it go with the buyer? Buyer pay installments? Seller pay the assessment? What's going to happen? If neither box is checked, then the buyer will pay installments due after the date of closing. Again, this is one example of a contract. Your contract in Pennsylvania or Ohio or California might be different. Just make sure you understand who's paying for what. That's where the details come in and where a lot of disputes come. Ambiguity or misunderstandings about who's supposed to pay. What about default? Who gets the advantage if somebody defaults? If the buyer defaults, the binder deposits may go to these fees and then retained by seller. If the seller defaults, the buyer might be able to sue or get a return or do other things. Basically, understand what are the remedies upon default. If you're a buyer and you decide, I just don't feel like buying this house, and you have a $10,000 deposit, that deposit might be gone, depending upon why you backed away from the deal. If it had to do with a finance contingency that's in the contract, then you might be okay. If it's because the title was no good, then you might be okay. But you want to know what are the different default triggers that mean different things. If the seller defaults, what does that mean? Can you force them to sell you the house? Maybe you can. If the seller defaults, the buyer might seek specific performance. That's a lawsuit that makes a judge give an order to the seller to sell the house. Again, legal questions, contact an attorney for more details. But at least know what your rights are. If a buyer fails to perform but is not in default, then what happens? The closing costs are responsibility of the buyer in this contract. Just understand what your obligations are and rights under your contract. What if there's a dispute about the binder? What if there's a dispute about who gets to keep the deposit? It tells you what happens in the dispute. If there's a dispute as to the entitlement of the deposit, then there will be either legal action. Sometimes there's requirements to do arbitration or mediation. Sometimes there might be a waiver of jury trial. Sometimes there might be a hold harmless of the broker. There's a lot of different rights. Again, remember to look at what is specific to your contract. Property disclosure. This is huge. Every state has property disclosures that you can't just say as a seller, I didn't know. Or you can't hold back information that you have about the property that might be of interest to the buyer. For example, if you know that the roof is about to cave in and you sell the house anyway, that's not something you can keep from the buyer. There are some very specific disclosures like rate on gas, energy efficiency, flood zone, defective drywall. There's all kind of disclosures you might have to do. Airport notice, if the property is in airport noise zones, right? Historic district, because sometimes if you're buying a house in a historic district, you might not be able to improve the house or change the house. In general, a seller has to disclose known defects with the house. Now, certain things are a gray area. Some states have weird laws about if you know somebody died in the house within the last 5 years, you have to disclose that. Some states don't have that requirement. Some states have a very specific property disclosure form that gets attached to this where you have to check off roof, electrical, flood zone, all the different things that you either know is a problem, know is not a problem, or you don't know anything about it. And it's important to keep a copy of that as a buyer, because if the seller claimed that they didn't know anything about it, but you find an estimate that was given to them from a contractor to fix that repair, now you have some legal action. What about maintenance? Well, basically it says the seller has to continue to maintain the property until the closing, right? You can't just stop taking care of a house after you sign a contract as a seller. You have to keep it in good condition. You have to, as a seller, make the property available for inspections so that the buyer can check it out, or have a property inspector or contractors check it out. If the buyer determines that the property is not acceptable during the inspection period, they can cancel. A lot of sellers now are trying to waive inspections. It used to be that you bought a house, you signed a contract, you had 30 days to do an inspection. If you didn't like it, you could walk away. In fact, in some contracts, it would say that if you did an inspection and you found defects or repairs that were needed, the seller had to pay up to a certain amount. Some contracts used to say if there are up to $3,000 of repairs found by an inspector, the seller had to pay for those repairs. That's less likely to be found or agreed to in current contracts. But be aware of what inspection period you do have. One strategy that you can use on properties where the seller is hesitant to give you an inspection. One thing you can do is to do an inspection kind of informally, meaning that you may not have an inspection clause in your contract that says, I'm going to inspect the property and I have 30 days to cancel. But maybe during the negotiating period, maybe you put in an offer, you're waiting for a counter offer. During that time, you just casually say, look, I want to take another look at something on the house. It's not an official inspection, and whether you do it, you have a contractor do it, you have an inspector do it, you have that done, and it may be less formal than doing it as part of a contract, but at least you'll be able to have somebody look to see if the roof's going to cave in, or if it has termites, or if the septic is backed up. Those are things you might want to know. Another important part of a contract is possession. Normally, buyer will be given possession at closing. That box is checked. If you are a buyer and you do not get possession at closing, be aware that there's some risks. If the seller is going to continue to live there for another 3 weeks because their new house isn't ready, or if there's a tenant in the house that's renting it that hasn't moved out yet, be aware that as soon as you close on a house that somebody else is living in, you now become a landlord. And that person living in the house might have tenant's rights to stay there, even beyond if it says, buyer will be given possession in 20 days. What happens if the person does not move out in 20 days? You might not be able to evict them. You might not be able to move in. So be very careful with not getting possession at closing. In fact, we recommend on the day of closing, before you go to the closing, go to the house to make sure everybody's moved out and take pictures and maybe do one last walkthrough to make sure the condition is the same as what it was. We have seen cases where the house is supposed to be possession at closing, and the buyer doesn't go to the house or doesn't look at it. They go right to the closing agent. They do their closing. They go to the house with their keys to move in, and they find somebody's living there. There's been some owners that, especially with the pandemic, have bought a house and couldn't move into it for a year because of eviction moratoriums. So be very careful with possession at closing. What about personal property? Sometimes when you are buying a house, there's things that aren't technically part of the real estate that are supposed to go with the house, like appliances, refrigerators, washers, dryers, generators, pools, that kind of thing. Make sure that you very clearly describe what is going with the house and what things are specifically excluded. You don't want to be buying a house thinking you're getting all the appliances and then you go to move in and everything's cleaned out. Now, there's some things that are included with a property automatically because they're appurtenant to the house. Things like light fixtures and bulbs, smoke detectors, drapery, those things are normally considered to be included. Plants, shrubbery. You can't just strip out a house. Things that are attached to the house are part of the house. What about riders? A lot of times a real estate contract will have additional documents that go with it. If it's a condominium, there's additional rules that go with the condominium. If there's an HOA, you have to disclose that and give copies of the HOA. Any house built before, I believe, 76 or 77 has to have a lead-based paint disclosure. Yeah, here it is, pre-78. Because a lot of houses use lead paint, and it's dangerous material. Continued marketing, meaning that during the course of this contract being in force, they might still show the house. So if you're a buyer and you have a contract, you might be surprised that the realtor is still showing the house. The seller is showing the house. And that might be because they want to have a backup offer in case you fall through. It might be because they want to get other leads to look at other houses. So be aware that you want to know, is the house going to be shown or not? Coastal construction. Some states have areas that are protected because they're close to the coast. Short sale, that's not something that happens anymore. But bottom line is, there may be addendums. Consider those to be equally valid to the contract because you have to sign them in addition to the contract. Other than that, this is the complete agreement. It means that nothing else the broker said, the seller verbally told you, that you thought was happening, you heard was happening, even things you saw in a real estate MLS listing aren't valid if they're not in the contract. If the real estate listing showed a boat in the background, and even if the listing said includes boat, if the contract doesn't say that, it's probably not going to be valid. Any emails that you got from the broker that said something about the property, they're not valid unless it's in the contract. Obviously, every contract, time is of the essence. You can't drag your feet. There's other disclosures about you have to give them your social security number, and then you have to sign it. Buyer, seller, buyer, seller. There could be up to 4 of each. Brokers have to sign it because they're responsible for the escrow of the money. And look, this is a 10-page document. We've been looking at it for half an hour, and we still did not get into all the details. The most important thing you want to look at is selling price, who's responsible for paying the different fees, and what happens if somebody breaks the contract. Those are the key things in any real estate transaction that you want to look at. Certainly, we recommend looking at the whole thing, and if there's something about it that's not clear, maybe contacting an attorney. In fact, your real estate agent or broker might be a good advocate for you. They might be representing you in the sale, but they're not a legal representation. As a matter of fact, they might be slightly skewed because they're getting a commission on this deal. If they point something out that might dissuade you from buying the house, they're going to lose out on a commission. So even though they're kind of on your side and trying to help you, you want to make sure that you're getting third-party unbiased advice. A good way to do that might be to engage with an attorney. Is it going to cost you some money? Yeah, you might have to pay an attorney 4 or 5 hours, billable hours, to review a contract, to look at different things. It might cost you $800 or $900,000, but in the context of a $500,000, 800,000 property or 1 million property, spending an extra $1,000 or $2,000 to have an attorney review a document, help you with maybe negotiations, help you with maybe understanding details, might make the difference in saving some money or avoiding some legal obligation, entanglement, or liability that you weren't planning on. That's an overview of a contract. This is a standard example, happens to be from Florida, but most states have something similar. The important thing is not to focus on this one example, but to look at what are the elements of a contract. Mortgage contingencies, who's holding money, who's paying for title, the major details, and the times. Closing within 30 days, inspection within 20 days. What are the time frames? A good realtor will give you a closing calendar of what's going to happen. Look, you have to give your second deposit within 5 days. Don't forget to get your termite inspection. Don't forget to do your mortgage application. A good broker will give you that timeline, but if they don't, read your contract and look at things like 10-day period to complete repairs, 20 days. Look at all your time so you know what your purchase calendar is and that you won't have any surprises because you missed a deadline or the seller was able to blow by a deadline. And some of those things might be inconvenient. Some of the deadlines might allow a party to escape a contract. In this day and age, with property values going up, some sellers might want to get out of a contract because they found a buyer for more money. So understanding the details is important. Getting legal advice is a good idea. And getting, even if you start looking at a property, get an example of a contract like this in advance before you even put an offer, so you've had time, maybe while you're still house shopping, to see how the contract is going to look for your particular jurisdiction when the time comes to make an offer. And you can ask those questions in advance rather than the day you're putting in an offer is the first time you see this. Sometimes it's not the best timeline of comfort to understand your rights in buying a house.